Right, guys. So normally my podcasts are quite informal, but today, just for time for John himself and for more information for you guys, I'm just going to question John, get as much information out of him as possible in the short time that we have. So we're going to start with, I'm going to be reading a lot of questions from my side as well. So we're going to start with this. Could you give me a summary of the SEC versus Ripple case?
Sure. December 22nd, 2020, the SEC filed a case against Ripple Labs for $1.3 billion, alleging that XRP for the last 7.5 years was a security, an unregistered security, and that what made this case unique from other cases is that they were claiming not just that Ripple used XRP in the early years as an investment contract, aka security, but at even today's sales of XRP are securities. And they went a step further than that and said that because Ripple created the secondary market, according to them, for XRP, that all secondary market sales of XRP are also securities. So for the first time ever, the SEC isn't just limiting its charges about a way a company packaged, sold, and marketed an asset, but they attacked the asset itself. And because of that, because they basically said all sales of XRP, including the secondary market sales, are securities. That's why Coinbase and Kraken and Crypto.com, all of them delisted XRP because they were saying today's XRP is a security.
Yeah, it's a very strange and interesting case. So, could you tell us how this lawsuit affects us as XRP holders?
Well, the main effect on XRP holders in the United States, of course, is that the major exchanges, Coinbase being the largest, delisted and suspended XRP. You can only purchase XRP on Uphold or BitTrue. There's not a lot of options. And so that's the first impact. The second impact is that a lot of XRP holders owned XRP in an iTrust Capital retirement account. Well, in the United States, because they're claiming all XRP are securities, those assets in the retirement account have been frozen until the outcome of this case. So for U.S. XRP holders, they can't convert their XRP to Bitcoin or Ether or cash or the euro or anything else. They can't access it at all. So for international holders, of course, someone in the United Kingdom where their government has said that XRP is not a security, yet they're impacted because of the global liquidity problem of or lack of liquidity in the United States. And so all XRP holders worldwide have been negatively impacted, obviously, by the case.
Yeah, I didn't realize that about the pension trust. That's very interesting and seems like a very strange thing to happen. So, what made you personally pick this case up?
Well, there was a kind of a joke, but it's not a joke. It's the truth. When the SEC filed this case on December 22nd, 2020, 9 days later, I filed my action against the SEC. And in January, I was on a podcast and someone said, "How long have you been a securities lawyer?" And I said, "Well, about 2 weeks now." And the bottom line is that I was a crypto holder. I owned Bitcoin and Ether and XRP and a few others. And when I read the complaint and I saw that they were attacking the token itself and claiming that all XRP are securities, including, in the secondary market, I knew what was going to happen. And so I filed an action, to be honest, sort of as a pissed off, angry, citizen of the United States, saying, I can't believe the government's doing this. Why would they do this? And then I also thought about, why would Clayton file this as he's walking out the door? Like, why a case of this magnitude would you drop it and walk out the door? And it just seemed awful suspicious to me. And for those reasons is why I got involved.
Yeah, I think that's awesome. And I think that a lot of your emotions resonate with the wider audience, especially anyone holding XRP, not just within the United States, but I know that, as you said, we definitely feel that in the UK specifically as well. So for the outcome of this case, how much do you think this is going to affect the US crypto scene and worldwide, depending on what happens?
Well, think about this. If the SEC is successful, in not just getting a verdict against Ripple, but if they're successful the way they're alleging the case and getting XRP declared a security, today's XRP, then every token is at risk other than Bitcoin, right? Arguably, because XRP is one of the first few tokens. It was created in 2012. If XRP is a security 8 years after the fact, then that implicates ADA, Algo, XLM, Ether, all of them. And so a ruling, the SEC would be able to use this ruling to say, hey, XRP had a better case because they were older and you're newer. And so therefore it equally applies to you. And so it really could impact all of cryptocurrency, certainly all the altcoins. And that's why people need to be concerned about it.
Yeah, and I think that that's something that a lot of people in the space who are just naturally against XRP and Ripple for whatever reason don't really or haven't taken into consideration yet that the wider effect that this could have on the market. But actually following on from that, I've got a little bit of a question myself that I would like to ask. So if XRP is deemed a security or from the SEC's argument, what is it a security of? Because we know Ripple have their own private equity. So is it a security of the XRP ledger? And if so, then how are they pinning that on Ripple? Because Ripple don't own the ledger specifically.
Right. Well, that's a very great question and a fascinating one. But if the SEC is successful, XRP would be deemed an investment contract of Ripple. Okay. Not necessarily the ledger. The reason why I'm in the case is to make that distinction that you just made, to basically say, listen, there are many other projects on the XRP ledger, and there are people who bought the XRP not even just to use it, right? People want to buy XRP sometimes just to use the decentralized exchange, the DEX that's within the XRP, or they want to use XRP as a bridge asset, to purchase Casino Coin or some other coin that's on the ledger. So, but right now, if the SEC is successful, it would be deemed an investment contract with Ripple, and then there would be some kind of potential you have to reimburse, purchase all the XRP. There'd be kind of some kind of project. What the SEC did with Veritasium, it's a small token, is that the SEC actually owns 98% of the token, and they've offered a buyback of people. And it's a very interesting way that they've approached it. They could try to approach it that way. But ultimately, if it's deemed a security, the main impact would be that Ripple can only sell to accredited investors. They wouldn't be able to sell to the open market. And unfortunately, Coinbase, Kraken, all of these U.S. exchanges, they're not security exchanges. They don't have a registration to sell securities. So they wouldn't be able to list XRP. It would have to be direct sales from Ripple or an exchange that has a securities license.
Okay, interesting. And actually on the back of that, this is going a bit off topic from my sheet, but on the back of that, we saw, I can't remember, I think it was Tom Emmer who spoke to a news channel, and he basically said that if XRP is deemed a security, how would it be able to be listed on the New York Stock Exchange or something of sorts? And what would your response be for something like that? I don't really understand the securities laws as well as I probably should.
Well, I don't think that it could be. They would have to change a whole format of registration and whatnot. Ultimately, it would have to be, as I said earlier, direct sales. They're not going to be able to list XRP, a digital asset, like they're listing Apple and all of things, because it is not, as you said earlier, it is not equity ownership into Ripple. Ripple wants to IPO, as a lot of people know, when this case is over. Those shares would be listed on the New York Stock Exchange or NASDAQ, but not XRP. But I think Tom Emmer was trying to point out the absurdity of declaring it a security.
Yeah, I completely agree. So if we have a negative outcome for this case, we've kind of touched on it there, but what would the implications be for XRP holders both within the US and worldwide?
It depends on everyone's definition of negative case. I think it's not negative if there is a ruling by the judge that between 2013 and 2017, when Ripple sold to a venture capitalist or to some other investment firm, that those early sales were unregistered securities. That would be fine as long as it followed, or the ruling said, but today's ongoing and future sales of XRP are not a security because they're sufficiently, the XRP ledger is sufficiently decentralized. If that happens, then it's great news. Even though Ripple might technically lose, the case, that would be great news for Ripple and XRP holders, because all they would do is pay a fine, right, and move on. If it is deemed a security, all of us, then it's what I said earlier, where it would have to be accredited investors, and there'd probably be some kind of program where current XRP holders would have the option of, getting what they paid for XRP or something.
Okay. Thank you for that. In your experience, is this one of the strangest cases you've come across in regards to potential conflicts of interest from the SEC and the timeline of events from commissioners? And are you allowed to answer this question?
Yes. It is the most blatant example of the appearance of impropriety. I've went on record to say I've never accused Bill Hinman or Jay Clayton or anyone else of violating a crime. With Bill Hinman, I said it looks like if that speech was 100% only his opinion and it was not for SEC guidance, then he could be in violation of Title V, which basically in the United States says you're not allowed to use your government office and your role to benefit yourself or your associates, right, financially. And so because his firm was a member of the Enterprise Ethereum Alliance, and their clients were being benefited, because when you declare Ether a non-security, it gives Ether great clarity, you could be in violation. So the appearances of impropriety are significant, and I think that they warrant an independent investigation, and that's all we're asking for. We're asking for, hey, someone look into this and pull people's emails, get phone records, get bank records. Does this just look bad and it's smoke but no fire, or is there a lot of smoke because there's a lot of fire? And I think ultimately it's in the SEC's best interest to do an investigation, because the SEC has no credibility right now as an agency, and it would behoove them to clean up. And if an investigation resulted in no criminal findings, but recommendations of what not to do in the future, that would still be a success for them.
Yeah. And I find it kind of strange being here in the UK and watching regulators when they do go to speak and using terminologies of like plurals like we or like associating themselves with the agency they represent, but then saying whenever they go to give any kind of opinion, they say it is their opinion and not that of the agency they work for. So it's very strange for me to watch. But this is my first time following any kind of lawsuit specifically, and I'm very interested in it, to be honest. So how do you think this case ends? If not in a perfect world or anything, what would you predict would happen towards the end of this case?
Well, I made a tweet. I don't know if you or your audience, I know some of them are. Are you familiar with who Brian Brooks is? Well, he used to be the Office of the Comptroller. He's now Bitfury's CEO. He's been testifying in front of Congress. I tweeted out and I tagged him on Twitter, and I said, Brian Brooks could settle the Ripple SEC case in 15 minutes or less. He would fine Ripple for early sales of XRP and declare today's XRP not a security, and then spend more time deciding what to eat for lunch. Brian Brooks responded to that and said, one correction, I don't eat lunch. So that just shows you he's saying, of course I could. That's the right decision. And it would give Gary Gensler a bragging rights. He could say, Ripple, let's settle. You pay $100 million, a huge fine, right? The last one was like $25 million for Kick or EOS. something not that significant, and ongoing sales of XRP are deemed not a security. You get clarity, you pay us for early transgression, and then get up and say, I have one of the largest SEC settlements in history. We held this new asset class. We brought them into compliance. We held them, and you get to have these bragging rights. That's the best way for both sides to win, right? And get what they want. It would also allow him to have the ability to go after other tokens if he wanted, because there's no adverse ruling against the SEC.
Sure.
Ultimately, I hope that that's what happens. I have to say, I always give my honest opinion. I fear that we could be headed toward a verdict.
Going to trial.
The judge or the jury trial, and then
Sure.
if that happens, that's going to prolong it. At least another 8 months, and that's unfortunate.
Yeah, sure. Because I saw and think. I was thinking about why that hasn't happened at the minute, and I'd probably like your opinion on that, because obviously we've seen Brad Garden House say that they're not going to settle if there's any terminology for XRP being a security as of current day. But I would have thought that it's in their best interest as for business and for everything else to settle the case. So do you think it's Gary Gensler himself who's specifically blocking a settlement at the minute?
Well, I think it's both, and I'll tell you why. So, Brad, here's the thing. If the SEC went to Ripple right now and said, you pay $50 million, $100 million for early sales, and we settle. We don't say anything else. We just settle. Coinbase doesn't relist XRP. Kraken doesn't relist XRP unless there's a declaration that today's ongoing sales of XRP are not a security, because Ripple needs liquidity to turn to increase in the United States, and because it does impact their business globally. I know they've been very successful overseas, but the U.S. is obviously a significant market. So I think they need that clarity, and I could see the SEC saying, "Well, we're not going to give you like that kind of future clarity." And that could only maybe come from the judge. And it's because of what you're on to right now is why I'm saying there's a chance that this does not settle, and we have to get some ruling. But that's why I insisted on trying to be in this case, because if there was any type of settlement or something, not that the judge would listen to me, but I would be pounding the table that, hey, XRP holders need a declaratory judgment from the court that says what we own, what we buy on the secondary market or in the secondary market are not securities.
Yeah. So you're basically saying, let them fight over the past. Let's come to some kind of agreement about that. And what we're doing now between us and going forwards, let's just have that as a separate case almost, or completely just push that under the carpet and give us some kind of definition for that.
Right.
Okay, cool.
100%. 100%. I mean, think about this too. You'd be surprised. People have heard the word Ripple because XRP and Ripple get used interchangeably, right? Sometimes.
Yeah.
But you'd be very surprised, maybe you wouldn't, that a lot of people would be surprised at how many first-time purchasers of XRP were completely unaware of a software company named Ripple that sold to banks and were trying to replace SWIFT with XRP. It's amazing how many people did not know about Ripple. So how do you rely on the promises and inducements of a company you don't know exists?
Yeah, no, I can completely see how that works as well. And I probably was one of those people back in like 2017. Like when I was just looking through different cryptos, all you see if you're looking through Coinbase, just the name of a crypto. And if you're just a punter and you're having a punt, then why would you ever know? Why would you know?
Well, here's the thing: how many people bought it because it was a top market cap and cheap?
Yeah, a lot.
Let's be honest.
I was one of those people. I was definitely one of those people back in the day. So yeah. Right, next question then. If we get regulation come through from Congress, for example, Tom Emmer's talking about bringing some regulation through for cryptocurrencies, and they do deem SEC not a security within that legislation. What does that mean for us as XRP holders, and what does that mean on your stance in this case?
Well, if they pass legislation that either took the that declared the CFTC as the body of jurisdiction, then arguably that could end the case. If they declare XRP itself not a security in the legislation, that would end the lawsuit. The only problem, it's a great theory, and Congress needs to act. I only say to people that requires someone like Tom Emmer to propose the bill, and then the people in charge, the Democrats that are currently in charge of the Congress, would have to bring it on the floor, get a vote for it, and then the Democrats in the Senate would have to also agree, get it on the floor, vote for it, and then get the president to sign it. And the problem is, in our divided country, right, or our divided world, really, what are the chances that in the next 6 to 9 months that they're going to come to an agreement?
Yeah,
you know what I mean? And so I don't want to be Debbie Downer. You know what I mean?
Yeah, no,
and I would love to eat my words and be wrong, but I just don't see it happening.
I was hoping within their like stablecoin regulations that were going to come out, they might just have a broad definition of cryptocurrencies at the current day. That's what I was looking for specifically.
I'd love to see it. Love to see it.
Yeah, me too. In a world where XRP holders could claim reparations and damages from the SEC, like how would this potentially come about? Is that something that's possible?
It's possible. It's a difficult hurdle. You have to show if they're acting in the normal course of their business, like a police officer, if he wrongly arrests you, you're right, you can't sue the police officer himself. He has qualified immunity. When you work for the government, you have similar qualified immunities. But if you can prove that there was wrongdoing, improper motive, let's attack XRP to give Ether or somebody else, the advantage, and you can prove that that person acted outside of their role as a government agent for their own interest, then yes. So you just need more proof. We have like these gross appearances of impropriety that look bad, smell bad, probably taste bad, right? But we don't have like the smoking gun yet of that's proof for sure. And so that's why we need an investigation, because that could uncover one of those. And if that got uncovered, then yes, they'd be a good case then.
Awesome. Right. So that leads me on nicely to my next question, actually. So could you explain to us what the SEC's thinking was behind specifically picking Ripple and XRP for their sales?
I can't. I can't, because I am baffled as to why. If you wanted a case, I can getting into the improper motive. But if you're talking about like why pick XRP, you would have picked Ether because it had a pure ICO, and there's videos of them admitting to it. There's their lawyer Stephen Nayeroff saying yes, it was the illegal securities offering. That would be the easier case to prove, right? If you want to prove today's token as security, then it would be harder to go after Ether because of the Hinman speech. Hinman speech gave them clarity. But if you're talking about the origination of the token, then it's a better case. And so I think that right now I have to put it to the bad motive that XRP was a threat and the lawsuit was used as a weapon. And until Clayton or Hinman or someone else offers a more plausible reason, I'm going to stick to that.
Yeah, it's very interesting. So when you say a threat, I presume, just to clear it up, you're talking about towards Ethereum itself because of like the potential connections between Hinman's pension and now like Jay Clayton at Fireblocks or wherever he is now, like those sorts of things. Is that right?
Well,
One River.
Well, that, but also Consensus and Joe Lubin. They bought Quorum from the JP Morgan coin in August of 2018, 4 months before the lawsuit. JP Morgan coin was designated a competitor of XRP by the World Economic Forum. for cross-border intra-bank remittances. And so that just looks like, boy, that's a big coincidence, right?
Yeah.
That Joe Lubin has these meetings with the SEC. He gets clarity for Ether, and then he starts bragging about how great the SEC is, while Hester Peirce is saying, no, it's not clear. It seems awful convenient. And again, until someone proves otherwise, there's like this prima facie circumstantial case that's the reason.
And yeah, that's what I was going to say. It's strange how Joe Lubin can talk about how he's got clarity before even the speech, William Hinman's speech, comes out. Exactly that. So, if in a perfect world for us as XRP holders, what would you like to see come from the judge in terms of this process and timeline for this case?
Great question. I would hope that the judge, at the time that the expert disclosure's over, which is the end of February, that in that period of time, say between March and April, that she would allow XRP holders for me to file a brief to the court seeking a declaratory judgment that today's XRP in the secondary market is by law not a security. If they give me that, then I'm out. The court's done with me and XRP holders, and then I need to try to persuade the judge that the only battle for Ripple and the SEC is about specific sales by Ripple. And since Ripple didn't sell to any of the XRP holders that I represent, then we shouldn't be held high. I mean, that's what I would like in an ideal world. What likely might happen is that at the same time that the SEC seeks a summary judgment motion to win and Ripple seeks a summary judgment motion to win, she would allow me to file my declaratory judgment as well. And then we all argue it all at the same time.
Okay. So fair enough. What if you're going to give me a percentage on the ideal situation? What is the chance that we could get the ideal situation come through? It's just a rough estimate. I'm not going to hold you to this. You told me how much?
50%.
Oh, really? Okay, that's better than I thought it would be.
Well, let me phrase that. It's 50. When you said ideal situation, I thought you meant like resolution of the case. Are you talking about that scenario with the judge?
Yes.
Which one?
Like if we had a resolution where the one where you could write in and say for us as XRP holders we're basically out of the case, and then they can argue about.
All right, that's 25%.
25%. I'll still take 25%. That's also better than I thought. I thought there'd be like a needle in a haystack sort of statistic. But okay, great. So, can I ask you a little bit about the regulation by enforcement by the SEC? Has this always been the case with the SEC? Do you think it's the most effective way? And if you do or don't, could you elaborate on that a little bit?
Well, I don't think it's the most effective way for market guidance and clarity. If you want to be in the business of enforcement actions, then it is. See, unfortunately, someone like Gary Gensler, they want optionality. And if you come out and you say, for example, let's take Ether. Why won't Gary Gensler say that he agrees with Bill Hinman that Ether is not a security, at least today's Ether? He's been asked that in Congress by Tom Emmer, and he won't answer it. He's been asked that recently on CNBC. He won't say it. All he has to say is, I agree with Bill Hinman that if you set aside the early fundraising, today's Ether is not a security. Why? Doesn't mean he's going to go after Ether, but he's keeping it on the table, right? He wants all options. And as a regulator, that's what a lot of them want. They want the option to be able to go after this one or that one. It's why they don't give guidance. It's why they say, I'm going to give a speech, but it's just my personal opinion. You can't consider it official SEC guidance, so that they have the option to go after whoever they want. The more vague it is, the better for them, right? Because if you're very clear, if you come out and say, this isn't a security, this isn't, right, then you don't get to go after all the ones that you just said are not securities. And so it's a terrible practice, but I don't see it ending.
Yeah, it's not great for innovation, and that's kind of crossed two further questions that I've got into one as well. So I will ask you that in a second about whether you think the SEC will go after Ethereum. But I also think it's strange that how the SEC are trying to argue that their piece to say, oh, the regulations are clear, but then at the same time not being clear when they get asked a specific question, they can't give a specific answer. So how can that provide any sort of clarity for anyone in the market? And what does that mean towards Ripple's fair notice defense? I'd like to know a little bit more about that, because I actually don't know too much about the fair notice defense in general.
Well, you might be too young, probably are, but there was a book by George Orwell called 1984, and they talked about government doublespeak, Big Brother that's coming after you, right? Everything's clear when it's not clear. And it's the way to basically the government to get their hands on you. And so, what was the question? I'm sorry.
I was basically just asking how, with Gary Gensler obviously coming out and saying, how does that help Ripple's fair notice defense or not in that situation?
Well, the number one thing that helps the fair notice defense is that Gary Gensler, before he was the chair of the SEC, he was at MIT, and he made a statement in 2018 that Ripple needed clarity. Like, those came out of his mouth. So that will be used in the court to show that there's no clarity. Also, Hester Peirce has come out repeatedly for years now, for over 3 years, to say she's criticizing her own organization that it's not being clear enough to give guidance. So, for example, when they had a settlement with the one exchange for selling unregistered securities, they didn't tell you which one were the unregistered securities, right? That would be like settling with Coinbase for selling unregistered securities, but not telling anyone which ones were the unregistered securities. And it makes no sense. And so I think Ripple has a good fair notice defense. And I think that the inconsistency of Gary Gensler, Hester Peirce, all of those are going to be very applicable to it.
Yeah, and for someone from the outside, that's something that really boggles my mind, is that you can have, like, obviously you talked about Hester Peirce, but also Elad Roisman, when he was there, was kind of on the side of Hester Peirce as well. And it just makes me feel like, is the judge really looking at this? Because if they've got 2 out of, 5 commissioners saying that there's no clarity, and 3 saying that there is, specifically the head of the SEC, and then basically Ripple, who are being sued, being like, well, I don't really know what's going on, and neither do the commissioners. How can the judge not see? Like, I don't understand where the judge is coming from. Why can she not just say, well, actually, here's what's going on there?
Well, we're waiting on her decision on the motion to strike. And I mean, if she throws out the fair notice defense, I'm pretty sure Twitter and the internet will blow up. You know what I mean? Because the ruling before her right now is simply whether or not Ripple can argue it.
Yeah.
Right. So I'm a little surprised that it's taken this long, but COVID, the judges has many other cases. So we will see. But I want to say something. I wanted to make a note of something, though. You said 3 out of the 5 said that there was clarity, right? Because you're thinking 3 voted for the Ripple lawsuit.
Yeah.
What's interesting is that it appears that Elad Roisman and Hester Peirce voted no, and Clayton broke party lines with the other 2 Republicans and voted with the 2 Democrats for the lawsuit. But now Clayton is writing editorials in the Wall Street Journal saying how it needs to be clear, which then makes you go back to the bad motive, right? You voted for the lawsuit on the way you're walking out the door, and now you're saying that things need to be clear and regulation needs to get it right, which makes it sound like you had bad motive to bring this case. And I think that people don't realize and recognize that it was in this divided world. I don't mean to get into politics, but when does the Republican go with the 2 Democrats against the other Republican? It's just, it normally doesn't happen, and so it just makes you scratch your head.
Yeah, it's a very strange one, and the more I look into it, the more it screams something's not right to me. But that's just me from the outside with not a lot of experience.
Well, if you read that Wall Street Journal editorial by Clayton, I mean, even Brad Garlinghouse couldn't resist
Yeah,
saying, "Come on, give me a break."
yeah, no,
You were just in charge a year ago, and now you're claiming
no,
that we need
we need clarity. Yeah,
right.
no, it's crazy. It's crazy. It's crazy. So, oh yeah, in regards to the SEC in this case with Ripple, and we've had two extensions in this case. Like, how common is that the opposer or the person bringing the case is the one who files for extensions, which I presume is normally the defendant who's not had any time to like rustle their defense up together. And in regards to that, didn't they have 8 years of communication with Ripple? So how have they not got all the information and evidence that they might need for a case like this?
It's very telling because let's say that they didn't know a lot about Ripple during the 8 years, but what they did know is they had a 30-month intense investigation into Ripple before they brought the lawsuit.
Okay.
That means subpoenas were sent, records were assembled, and in 30 months, they didn't find fraud. They didn't find misrepresentation by Ripple, because if they did, they would have charged it.
Mm-hmm.
Yet, after 2.5 years of investigation, they need more time. Now, I think more than anything, it underestimated the legal team Ripple was going to assemble, right? And so we know, for example, that there's 16 experts in this case, 8 on each side. And when you have the former SEC chair, Mary Jo White, and when you have who used to have Clayton's job, and then they have someone a lot of people don't know, Meredith Cross. She's part of the legal team. She used to have Bill Hinman's job. And then you have Andrew Seresny, who is the former director of enforcement at the SEC under Mary Jo White. They know how to, they work there. They were in charge of enforcement. So they know the right questions to ask. They know the right documents to ask for, and I think that the SEC just probably is overwhelmed by the defense, and so they needed more time to get all their ducks in order. And so I think that the judge in the case, I know a lot of people are frustrated. The judge in the case wants to be able to say that she gave both sides a fair trial, because she doesn't want an appeal, she doesn't want to get overturned. And so if the SEC wants an extra couple months in the biggest securities case in 76 years in a non-fraud case, in the grand scheme of things, I'm going to give them a couple extra months. You know what I mean? It's just sort of you're being an impartial person.
Yeah, and I can understand that, and that's what I had as my perspective. But obviously, a lot of people, my followers and community, get quite emotional and upset when there's an extension. I can understand that, but I can also understand it from the perspective of the judge. And from my presumption, the SEC probably just thought they'd just throw a lawsuit out to Ripple, have a quick settlement, take some quick cash, but then Ripple assembled, like as you say, a big team, and they've got big backing. But one thing that I think is quite interesting, as you were talking about, is ex-SEC staff on the side of Ripple. So surely they know exactly what all the internal conversations have been at the SEC, and I don't really understand how, again, this lawsuit isn't. When do people get to show their hands in this case? Am I getting this question out right? When do Ripple say, okay, well, we've got these documents, we know this, and the SEC, and maybe they meet and they talk about a settlement? Like, when does that conversation happen?
Well, it would happen. A lot of people don't realize is that Ripple hasn't gotten the documents yet, even though the judge ruled that they were relevant 2 previous times and need to be turned over. And then she just ruled on the privilege issues. So right now, what she's ordered turned over is the email that has the draft Hinman speech, and also notes of SEC lawyers like the crypto czar Valerie, that notes that they took during meetings with non-Ripple entities or companies. And who are those companies? Joe Lubin, Consensus, the Working Group, Perkins Coie, Andreessen Horowitz, all of them. And so, but the judge just also in her recent ruling said that the SEC can still invoke attorney-client privilege within those notes.
Okay.
For your audience, what that means is if the lawyer for the SEC, when they were meeting with consensus, writes down, Joe Lubin said X, Ripple gets that.
Mm-hmm.
But if the SEC attorney said, Joe Lubin said X, and I think this means is the mental impression of the attorney for the SEC, that would get redacted. Mm-hmm. So that still has to be done. So I don't think Ripple's going to get the documents for another month.
Okay.
Then, what's in those documents, right? And so people ask me about that decision. The judge, was it for the SEC? Was it for Ripple? Was it a split win? It all depends on what's in the notes and the email. If there's something in there really, really good for Ripple, then it's a great victory. If there's nothing, right, if all the notes say is, they're asking for Ether to get the safe harbor, or they're asking for Ether to arguing that it's sufficiently decentralized, and there's no mention of XRP, it's not that big of a victory. And so we just don't know until we see them or read them, then we'll know. But if there's something really exculpatory that helps Ripple, then I think the SEC would be more inclined to talk settlement.
Okay. And surely, well, you'd hope that some of their ex-SEC staff that are on Ripple's legal team now were in some of those meetings, so they might know what is coming in those documents.
Right.
So at the point that the SEC filed a claim against Ripple, they could probably have filed that suit against a number of different cryptos. Do you know why they specifically chose Ripple? Was there a specific vulnerability or an action by Ripple that caused this sparking of the case?
Well, I know that Brad Garlinghouse at one point said he questioned whether or not this was personal because of the Jay Clayton thing. In one of the documents I filed, I talked about different theories of why the case was filed against Ripple. One of them was personal gain. We've talked about the conflicts of interest. I also put in there as an option of, was it sort of an FU as you walked out the door, because Ripple had a lot of pressure put on Clayton. You had John Radcliffe sent a letter to Clayton saying that he was favoring Chinese technologies, Bitcoin and Ether, over American innovation. That was the National Security Advisor. Tom Cotton, a senator, sent a letter to Clayton saying, criticizing Clayton. Ted Budd and several congressmen also sent a letter to Clayton. A Washington Examiner had done an investigative report. Stuart Alderati was quoted in there criticizing Ripple. And of course, Ripple had criticized the Trump administration and said that, quote, the Biden administration had to be better than the current administration. Doesn't turn out to be true, but so those are the thoughts. I think the only other answer is the escrow, and the fact that they believe that Ripple owning 51, 52, 53% of the outstanding XRP makes it different than the others, right? Whether Vitalik or Joe Lubin own 9% or 10% of Ether at some point, it's not 53%, right? And so they believe that the centralization of the token is what distinguishes. That's the only legitimate. But here's the problem with that. There's no Howey factor that says how much does the person own.
Yeah.
Right. It doesn't make XRP a security, but it could be the only non-bad motive reason why they're going after Ripple.
Sure, okay. Because that's what I always thought about that securities law, because if that is their argument, that it's because they hold so much, if it's obviously can't really happen because he doesn't have enough money, but if, for example, someone like MicroStrategy and Michael Saylor bought up over 50% of the Bitcoin supply, would they then be holding a security? And sure. Then that was my thought process on that, to be fair. So what I'm going to do, John, because we've only got 10 minutes left, I'm going to go straight to a couple of community questions because you kind of answered a few of these that I've got written down here, and then yeah, we'll just wrap it up there if that's all right with you. So
Sure.
we've got one from Richie Dobson, which we have kind of answered, but I'd still like you to answer this one specifically. So Richie Dobson asked, "Hi John, the SEC rarely loses a case. Can this be resolved amicably for both parties?" And I think we talked about the settlement idea. Do you think that's the best way we can get a amicable?
Absolutely. I was hoping that XRP would experience a bull run, get up to $5. They could sell 100 million XRP from the escrow, and that's a $500 million settlement. Write a $500 million check to the SEC. Gary Gensler gets up and says, "I've got the biggest settlement or one of the biggest settlements in SEC history. I held people accountable. Today's XRP is not a security," and everybody goes about their businesses. I know I'm being a little bit facetious, but I'm being honest. That is the most logical explanation. Early sales of XRP between 2013 and 2017, these specific sales, transfers, unregistered securities, pay us 50 million, 10 million, 100 million, whatever the number is, ongoing future sales, not a security. Everybody wins.
Awesome. Yep. Someone asked, Mr. Willow78 said, for this case, do you get to contact and are you in contact with the Ripple defense team?
Well, the judge said that I'm allowed to participate in the briefs and in the arguments, but she restricted me by saying that I'm not going to let Deaton call witnesses. And she said that Ripple has the same motive and opportunity to basically find out what I think should be presented or what evidence I would present. So I'll say that there's been some contact, but I would never divulge any kind of conversations.
Sure, thank you for that. This is a great question here from R3P. He says, we've not seen any international interventions or challenge of communications, as many countries don't seem to deem XRP as security. He's basically asking, it's quite a long-winded question, but he's basically asking why we haven't seen anyone, so say like from Japan or from the UK, where we have quite clear legislation. Why have they not talked to the SEC and said, "Oh, this is what we think here"? How are we so far apart on our legislation?
I think that if you look at meetings that Gary Gensler and Jay Payton have, sometimes it'll say the UK's Financial Conduct Authority, for example, that there's meetings. I would imagine in those meetings it gets discussed. Of course, the UK Financial Conduct Authority is going to say, we're not going to interfere with US securities regulations in the courts, just like we don't want the United States telling us what to do or how to do it. I think that the best thing would be for the international holders to contact their agency and say, I think that you should, petition the chairman of the SEC and let him know that it's impacting us over here. That's the best way to try to get something. But unless they get pressure from their citizens, they're just going to have a hands-off approach. They'll probably assume that there's a settlement. A lot of them, let's face it, 95% of the cases settle. So these agencies are probably saying, hey, the SEC wants to tax Ripple, right? That's what they do. Let them tax Ripple and move on. And they probably are underestimating the impact it's having.
Sure. And so off the back of that, I've got another double question. So depending on how this case finishes, do you think that will set any jurisdiction for the rest of the world? And then after that, just because I don't want to forget, but I will re-ask, and how can we get involved in this case as XRP holders outside of the US jurisdiction?
Well, let me ask that because that's important to me. 2 days ago, on Twitter, I notified the world or Twitter world that on CryptoLaw.us, we have an international Connect to Congress tab. And what you do is you go on there, you tab it, and it uses change.org petition. And that petition is to petition the banking committee in the Congress and the Senate. And what I plan to do is say, listen, right now we have 9,000 international holders who have signed up, and we have 10,500 U.S. Citizens who have signed up. And I want to go to the banking committee that has the oversight of the SEC and say, listen, look at the impact this is having, and all these international holders are impacted, the U.S. voters are impacted, and try to get an investigation into, to answer some of these questions. So that's something that they can do. How much of an impact it's going to have, all I say to people is it certainly doesn't hurt. If I can go in there and say I've got 25,000 U.S. Investors and I've got 25,000 international investors, it just makes the argument that much more powerful.
Yeah, for sure. Thanks for that. And I will put the link to that in the description of this video for anyone who wants to check that out, as I will with your social media, different platforms. And the last thing I'm going to ask you is from Fibo-san. He says, this kind of goes back quite a way into the conversation we were having, but what information do you think we'll find from the William Himon emails that they've had for preparing for William Himon's speech? Do you think we'll find anything from those?
I think we'll find something, or Ripple will, that is helpful. I wouldn't be surprised if it leads to them needing another deposition of someone. But there were 63 people on that email, or there were either 63 emails back and forth, and we know that Hester Peirce wasn't on it. So the question is, will that email lead to find out what you said earlier? You said in this podcast that before the speech, Joe Lubin sort of alluded to things that were in the speech. Did he see a copy of that speech? Something like that could really, really be significant.
Okay, great.
But I just don't know,
Yeah, for sure. So that's everything, John. Thank you very much for your time. Guys, as I said, I will have the links to John's social medias and the channel. And also, if you want to be getting involved in this case, we're going to put the link to that in the description of this video. John, would you like to say anything to sign off to everyone on the podcast?
No, just thank you for all the support, and please go to the international for the international viewers who are watching. Go to Crypto Law, sign up. It's free, doesn't cost anything, and it could make a difference. And so all we can do is either sit back and complain, or engage and get involved in the best way we can. But that would be it.
Yeah, definitely. And we've got a strong community here, XRP holders, and over here in the UK. So I'm sure we can rally together and help you out with that.
Yeah, I've been in contact with several of the UK, probably some of your viewers in this case, getting affidavits or even speaking with a few. And the XRP community is probably, in my honest opinion, the most intelligent and passionate of all the cryptos.
Yeah, I'd agree with that. I think we put a lot of time into and research into it. I think it's quite a hard asset to hold if you don't, because everyone floods on it all the time.
Yeah.
Right. So that's everything, John. Thank you.
Thank you.